Welcome to Still Unanswered. I'm Elena Marquez. Today, we're returning to a case that feels, even now, like a hall of mirrors. So many reflections, so many contradictions, where the brutality of a killing and the performative theater around it created a public narrative that still doesn't sit right. We're talking about the murder of Travis Alexander and the conviction of Jodi Arias. This is not a retelling for the curious. It's an unpacking for people who know the headlines and want to sit with the gray. With me is Dr. Calvin Rhodes, forensic psychologist. Calvin, thank you for being here.
Thanks for having me, Elena. It's a case that keeps us up late in the field because the psychological, legal, and cultural questions it raises keep bumping into each other. There's a lot to sift through.
Yeah, so let's start with why this case belongs on this podcast. The facts we can agree on. Travis Alexander was found dead in his Mesa, Arizona home on June 9, 2008. The injuries were savage. 27 stab wounds, a deep throat laceration that severed major vessels, and a .25 caliber gunshot to the head. The camera recovered from the home held photos taken that same afternoon, images that placed Jodi at the scene, sexually posed with him, and then a chaotic final frame. Those physical anchors are incontrovertible, but beyond the facts, we're left with a spool of questions. Was this premeditated? Was it a frenzied act of rage? What is the truth about Travis and Jodi's relationship? And how did the media and courtroom theater shape our perception?
Right. And to add, the case was litigated in the open, literally televised gavel to gavel. That exposure isn't just background noise. It's an active variable. It changes juror pools, it changes witness behavior, it changes public appetite for simplification. So as we go through timelines and evidence, keep asking, which pieces answer a question and which pieces create new ones?
Good. Let's take this chronologically to give listeners a clean line to hang on to. First, who were these two, Travis and Jodi, before they became a case? Travis Victor Alexander, born in 1977 in Riverside, moved into his grandparents' home after a rocky childhood. He rose through a sales and motivational speaking circuit, prepaid legal services, later Legal Shield, cultivating an image of drive and self-improvement. He was devoutly Mormon in public life, emphasizing chastity and morality, but the public record from the trial revealed a far messier private life, nude photos, explicit texts, and behavior at odds with public piety.
Yes, and those dual images matter, Elena. People are complicated, most are, but in this case, the tension between his public religiosity and private sexual behavior became central to how defense and prosecution framed motive and character. Forensic psychology tells us that identity inconsistencies, especially when one's social status is at stake, can create interpersonal conflicts. But, crucially, conflicting presentations of a person do not automatically explain or excuse homicide. They complicate motive narratives.
And Jodi, she's often reduced in headlines to a caricature. Born 1980 in Salinas, she worked as a waitress before also becoming a salesperson at PPL, where Travis was already making waves. She converted to Mormonism after meeting him and seemed to recenter her life around him and his world. Many casual acquaintances called her soft-spoken or sweet, but the trial record includes testimony about jealousy, boundary crossing, and obsessive behaviors. Post-trial, experts argued different diagnoses. Prosecution's Dr. Janine DeMarte described borderline personality disorder. Defense expert Dr. Richard Samuels argued PTSD and trauma. Calvin, how do those competing clinical portraits influence our interpretation of motive and culpability?
They influence how we read behavior, but not necessarily the act. Borderline personality disorder, if accurately diagnosed, can involve intense fear of abandonment and unstable relationships, which can predict self-destructive or extreme relationship behaviors. PTSD, on the other hand, frames responses as rooted in prior trauma and hyperarousal. Sudden disassociation in a fight could be argued under that model. Clinically, both can explain dysregulated responses to interpersonal stress. The problem is translating that nuanced language into a courtroom scripted around guilt or innocence. Labels can be persuasive, but they're not proof of intent to kill.
Right. That's an important distinction. Now, their relationship, it escalated quickly after meeting at a PPL conference in 2006. They lived a push-pull life, on again, off again, with an intense sexual component, evidenced by explicit messages, phone sex recordings, and photos. That sexual life directly clashed with LDS expectations. Prosecutors framed Travis as a basically decent man caught between desire and faith, and Jodi as someone who used sex to maintain control. The defense argued the opposite, Travis as duplicitous and exploitative, worst of both worlds. So, was this toxic chemistry enough on its own to explain what happened on June 4th, 2008?
Toxic relationships can create chronic stress and escalate risk, but homicide usually requires a precipitating event. In this case, there were potential triggers: Cancun trip news, alleged stalking behaviors, intense arguments. But we must be cautious. Toxic dynamics increase risk, but don't determine a specific violent outcome. The forensic question becomes, did a particular planning behavior point to intent, or did an argument cross a threshold into lethal violence?
Let's get into that planning question. Prosecutors raised several premeditation indicators. The burglary at Jodi's grandparents' home in late May, where a .25 caliber Colt pistol went missing. The rented car driven thousands of miles with indications it had been cleaned. Testimony that she borrowed gas cans to travel long stretches without paper trails, and phone records showing strategic shutdowns. The camera found in Travis's house, later discovered in a washing machine, shows photos taken that afternoon, intimate poses, then shower shots, then the final bloody image. Taken together, the prosecution argued these were more than coincidences. They were the scaffolding for a planned murder.
Those are powerful pieces. From an investigative standpoint, the missing gun and travel planning are classic indicators of preparation. The difficulty, though, is establishing purpose. Was the gun taken as a tool for intimidation, for self-defense, for murder? Intent can be inferred from patterns, but inference is not the same as certainty. Also, the actual murder weapon was never recovered, which creates an evidentiary gap. The digital camera timeline is damning in its placement of Arias at the scene, but it doesn't answer the mental state behind the actions captured.
That unresolved weapon is something I want to come back to. But first, let's step into June 4th itself. The digital trail places the events in the afternoon, photos taken, intimate images, and then violent sequence. Travis's body, he was found in the locked master bathroom days later, slumped in the shower. The medical examiner described 27 stab wounds, a throat laceration that severed the carotid and trachea, and a gunshot to the head. There were defensive wounds and a mixture of blood pools and attempted white marks, some signs of a hasty cleanup. A bloody palm print contained DNA from both Travis and Jodi. There was no forced entry. Those are the unyielding details that anchor any narrative.
Agreed. The injury pattern is instructive. A deep throat cut that severs major vessels suggests intent to kill. Attempting to disable breathing and blood flow is rarely an accidental injury in a struggle. The number of stab wounds and their distribution, torso, back, hands, speaks to overkill in some respects. But sequencing matters. The medical examiner gave testimony that could be interpreted different ways about whether the gunshot occurred before or after the stabbing. If the stabbing occurred while Travis was already mortally wounded or incapacitated, that suggests a different mental state than if stabbing preceded the gunshot. The ambiguity of sequence is one of the case's technical sticking points.
And that ambiguity was center stage in trial theatrics. Before we move to the courtroom, one short but stark moment. Friends finding the body on June 9 after his absence triggered alarm. They called 911. One of those friends, named Jodi Arias, almost immediately as a suspect. The camera data, voicemail behavior, and the rental car's mileage folded into an investigation that made her the clear focal point. But then her story changed 3 times. She initially said she wasn't there, then invented masked intruders, and finally admitted to killing him but claimed self-defense. Calvin, what does that sequence of shifting stories do to a defendant's credibility in a high-stakes trial?
It destroys it, at least in the public and juror eye. Consistency equals credibility in court. When a narrative shifts dramatically, especially from denial to a convoluted intruder story to self-defense, the jury is primed to view the defendant as deceptive. That perception can be decisive, even if there are plausible explanations for the shifts, like fear, shock, or attempts to avoid immediate self-incrimination. Clinically, we sometimes expect people to give multiple accounts when coping mechanisms and cognitive processing are impaired. Legally, however, the lever is credibility, and credibility is often the central evidentiary battleground.
Right, and Martinez, the prosecutor, zeroed in on those inconsistencies with the kind of showmanship that became its own controversy. Let's go through the trial. It began in January 2013 in Maricopa County with cameras in the room. Martinez was aggressive. His cross-examination of Arias won headlines, and he wove a narrative of jealousy, premeditation, and cold calculation. The prosecution emphasized planning: the stolen gun, the gas cans, the photos taken to document the act, and allegedly calculated post-crime behavior like the voicemails left after he was already dead. The defense countered with a picture of a battered woman, abuse, manipulation, PTSD. How do you evaluate those competing frameworks, Calvin?
You evaluate them by the standard of proof. The prosecution must demonstrate beyond a reasonable doubt that the killing was premeditated and intentional. The defense only needs to inject reasonable doubt. The abuse narrative aims to explain motive and the mental state that could mitigate culpability or support self-defense. The success of that narrative depends on corroboration, witnesses, contemporaneous reports of abuse, physical injuries prior to the killing. In this case, the defense had some testimony suggesting emotional manipulation, but lacked police reports or prior documented physical violence, which weakened the claim for many jurors. The prosecution's physical circumstantial evidence of planning was persuasive enough for a guilty verdict.
And yet, the jury did convict for first-degree murder, finding premeditation. After the guilty verdict, the penalty phase deadlocked twice. The first jury hung 8-4 for death, then a second jury deadlocked 11-1 for death, and the judge imposed life without parole because unanimity is required for death in Arizona. 2 holdouts. That's striking. What do you make of jurors who were persuaded of guilt but not unanimous for death?
This is one of the most interesting psychological puzzles here. A juror can separate guilt from moral judgment about the death penalty. Reasons for holdouts vary. Some jurors are philosophically opposed to capital punishment. Others feel there's lingering reasonable doubt when it comes to premeditation versus a crime of passion. Remember, the death sentence requires a different type of moral calculus. It's not only about whether she killed him, but why and how much culpability. It suggests that, in at least two jurors' minds, something about the defense's narrative or the prosecution's case left an irreducible hesitation about the ultimate punishment.
One juror in the second penalty phase persisted alone against death 11-1 to death. People asked, was that juror wrong? Heroic? Irrational? The open question, still unanswered, is what that juror saw that others didn't. We can't interview the juror's inner life, but we can look at the kind of doubts that reasonable people might hold. Uncertainty about the gun's origin and use, ambiguity about the sequence of wounds, possible misconduct by the prosecution. Speaking of which, let's address prosecutorial conduct. In later appellate decisions, the Arizona Court of Appeals criticized Juan Martinez for improper questioning and conduct, though they ultimately upheld the conviction. How significant is that critique, Calvin?
It's significant for two reasons. First, it raises legitimate concerns about whether justice is being pursued or performance is being prioritized. When a prosecutor crosses lines, improperly impeaching an expert witness, for example, it risks prejudice that could taint a jury. Second, even when an appeals court finds misconduct, they often evaluate whether the error was harmless beyond a reasonable doubt. In Arias' case, the court found misconduct in some areas, but determined it did not so infect the trial as to require reversal. That's a legal standard about outcomes, not a moral clearance. The presence of misconduct stains public confidence, even if the conviction stands.
And Martinez's later disciplinary troubles, people working later to disbar him, add a postscript that keeps the case unsettled in the public imagination. Another major tension, the media. The trial was a spectacle. Nude photos, phone sex recordings, intimate texts were televised and replayed endlessly. Cable pundits turned personnel details into personality judgments. I want to ask you, how does saturation media coverage influence jurors and the fairness of the process?
Complete isolation from a media fever was effectively impossible. Jurors can be instructed to avoid media, but when your case is top of cable and social feeds, cognitive contamination is likely. Media also primes narratives, creating expectations about what a guilty look is, what a manipulative demeanor is. That can influence which testimony jurors find credible. Moreover, the public spectacle can push legal actors, witnesses, prosecutors, even judges, toward performances that unconsciously cater to a broader audience, strain that changes trial dynamics.
Listeners, pause with me for a moment. Think about the human cost. Travis's siblings and family say they live with daily trauma, seeing their loved one's body and the photos and evidence, watching his image get dissected on national television, enduring 2 penalty phases. Jodi's family lives with public hatred and threats. 2 sets of humans carry this forward.
Exactly. In forensic work, we often remind ourselves, beyond evidence and argument are lives, trauma, grief, hatred, and sometimes the slow, grinding injustice of public narrative. Both families are victims in different ways of a process that turned private pain into entertainment. Both families are victims in different ways of a process that turned private pain into entertainment.
Let's pivot to some of the still unanswered forensic and legal questions that keep this case alive in academic and true crime conversations. First, the missing gun. It was reportedly stolen from Jodi's grandparents' home during a burglary May 28, 2008. The murder weapon was a .25 caliber round, but the actual gun was never recovered. Prosecutors used the burglary as evidence of premeditation. The idea was she obtained and concealed a weapon in preparation for killing Travis. Defense called it coincidental and argued the link was speculative. How do you weigh a missing tool like that, Calvin?
The missing gun is a suggestive, circumstantial piece. In a murder case, a missing weapon that matches the caliber used provides an inference that the accused planned. But we should emphasize the limits. Without recovering the weapon, we lack ballistic match, fingerprints, or other conclusive linkage. The inference is still valid legally, but it's probabilistic. For a juror predisposed to doubt, that missing piece can be a door ajar, an unresolved doubt that might explain a holdout on a death sentence.
Second unresolved element, sequence of injuries. If the gunshot came first, it might align with a self-defense narrative, an attempt to use the gun in a scuffle that went sideways. If the throat slashing and stabbing came first, that suggests deliberate execution. The medical examiner's testimony left room for interpretation. What about that ambiguity, clinically?
Sequence is huge. The ME testified with authority, but forensic pathology can have limitations depending on decomposition, wound morphology, and blood spatter. The presence of multiple stab wounds and a throat cut that severs major vessels is highly suggestive of an intention to kill. Yet, a chaotic struggle can produce multiple stabbing wounds too, especially if someone is frenzied or dissociating. In the end, the sequence ambiguity means reasonable minds could differ about whether the act was deliberate execution or a catastrophic escalation, a core reason some jurors might waver on ultimate punishment.
Third unresolved element, the intruder story. She first lied, claiming she wasn't there. Then she claimed masked intruders. Finally, she admitted to the killing. The intruder claim had no corroboration, no physical signs of forced entry, no other DNA, no plausible motive for intruders to leave her alive. So most experts consider that a demonstrable lie. But why invent such a story? Fear? Legal strategy? In your experience, what drives that type of fabrication?
Fabrication after a traumatic event can come from several sources. Immediate fear of retaliation, attempts to avoid arrest, confusion, or an instinctual lie to protect oneself or family. Some people attempt to invent an external villain because it's easier to conceive of an explanation than to sit in the terror of one's own possible culpability. Legally, it's disastrous because it corrodes credibility. Psychologically, it's a coping strategy that fits with someone not prepared for the consequences of acts that spiral out of control.
Let's talk about the domestic violence narrative. The defense introduced experts who said Arias fit the profile of a battered woman, that Travis was emotionally abusive, secretive, manipulative, and demanded sexual things he publicly condemned. The prosecution, and many of Travis's friends and family, rejected that framing and argued it was manufactured in service of a self-defense claim. How do we, as outside analysts, evaluate the legitimacy of those abuse claims, given the case's polarized media environment?
We evaluate them by triangulating sources. Objective indicators of ongoing physical abuse, medical records, police reports, contemporaneous witness statements carry more weight than contested online narratives. Here, the lack of documented prior physical violence, combined with explicit sexual records, complicates the battered woman narrative. That doesn't mean emotional or sexual manipulation didn't happen. Textual evidence suggests unease and conflict, but it does mean that translating that into a legal justification for lethal force faces evidentiary hurdles. The courtroom requires a level of corroboration that domestic dynamics don't always provide.
And yet, the prosecution used the releasing of sexual evidence against Arias' photos, phone sex, as character evidence in a way that some say amounted to victim blaming. The public saw those images and began to assess whose pain mattered more. That's where gender and narrative bias come roaring in. If a woman is sexual and doesn't exhibit expected grief behaviors, she's judged differently. The Ariana case raised hard questions about whether an attractive, sexually expressive woman will be given the benefit of the doubt when she claims abuse.
Absolutely. Gendered expectations are baked into juror psychology. There's research showing that women who deviate from feminine stereotypes, domestic, demure, sometimes lose sympathy in court, especially in intimate partner homicide cases. The Arias case became a public test of those biases precisely because it involved eroticized evidence and an attractive defendant who some saw as glamorous. That dynamic likely influenced how witnesses were interpreted and how Arias herself was judged on camera.
Another persistent set of questions centers on prosecutorial theater and whether the search for spectacle actively skewed fairness. Martinez's performance, his pointed, sometimes aggressive cross-examinations, made headlines and later became fodder for appeals. Some courts criticized his conduct. Looking at that, do you think the court of public opinion and the court of law were mutually reinforcing in ways that risked justice?
They certainly can be. When a prosecutor performs for cameras, it can alienate some jurors but persuade others. A showman prosecutor cultivates a narrative of certainty that can overwhelm nuance. Judges have an obligation to control courtroom conduct, but when the public is watching, every reaction is amplified. The appeals process can correct some procedural wrongs, but it can't unmake the public impression once it's formed. That tension between fairness and theater defines modern high-profile trials, and Arias's case is a prime example.
Let's talk about the holdout jurors. Twice. We already touched on possible reasons, but I want to get deeper. What kind of reasonable doubt might persist after a guilty verdict that makes a juror oppose the death penalty? Is it the sequence of wounds, the missing weapon, the possibility of evidence being mischaracterized, or something else, like a moral objection to the state taking a life?
All of the above. The death penalty requires jurors to navigate both fact and morality. A juror might accept guilt based on cameras, DNA, presence at scene, but still see a lack of definitive proof of premeditation required for death. Shot sequence ambiguity, lack of a recovered gun, questions about evidence handling, like the laptop pornography revelations in the second penalty phase that suggested earlier testimony may have been incomplete, all can seed doubt. Additionally, a juror's personal moral compass, religion, prior attitudes toward capital punishment, can make them a holdout regardless of evidentiary detail. In a close case, any one of these can be decisive.
Another under-examined element, the police and investigative choices. For example, the rental car returned with missing floor mats and red stains. The car was cleaned before thorough analysis, and some evidence streams, like the exact path of the gas cans and Walmart receipts, had gaps. The defense later highlighted inconsistencies in witness testimony about a gas can return, and police's initial statements about no porn on Travis's laptop were contradicted later. In your opinion, do these investigative inconsistencies reflect sloppy work, biased assumptions, or honest limitations?
Probably a mixture. Every investigation has limitations: degraded memories, lost receipts, human error. But in high-stakes cases, small errors or oversights can have oversized impacts. If the investigative team is operating with an early fixation on a suspect, confirmation bias can steer their attention away from alternative theories or careful documentation. That's one reason the defense was able to exploit these inconsistencies during the sentencing retrial. It doesn't mean the conviction is wrong, but it does indicate mystery where certainty is often claimed.
Let's pause for a human moment. Travis's family endured the trauma of both his violent death and the public spectacle that followed. They were forced to confront intimate images of their loved one and a defense that, to them, smeared his memory. Jodi's family has for years faced death threats and community shaming. Two families reoriented by violence and media. It's easy to forget that in debating narratives. Calvin, how do you counsel families in cases like this?
I emphasize acknowledgement of pain and the limitations of the legal system to soothe grief. Families need accurate information and psychological support separate from the media circus. I also encourage them to focus on long-term healing rather than the short mania of headlines. That's rarely easy when the world continually replays images or runs new takes.
Another angle we should address: the cultural legacy of the case. It's a staple of true crime programming: books, documentaries, endless podcasts, often framed as a morality play or a sensational thriller. Some argue the relentless retelling serves public education about domestic violence. Others say it profits off real people's pain. What do you think?
Both are true. Retelling can educate, highlighting how relationship dynamics can turn deadly, the warning signs, the importance of intervention. But when the retelling is sensationalized, focusing on salacious or voyeuristic elements, it risks exploiting trauma and skewing public perception. Ethical storytellers must balance narrative drive with responsibility to victims and accuracy.
Looking forward, there are legal threads that remain open. Arias exhausted direct appeals. Post-conviction relief petitions could theoretically surface new evidence or show constitutional violations. Practically speaking, given appellate rulings and the critiques of Martinez that nonetheless left the conviction intact, how realistic are prospects for overturning this verdict?
Pretty slim. The appeals courts have already reviewed major claims and found, in effect, that errors, where they existed, were not outcome determinative. Post-conviction relief is possible, but requires either newly discovered evidence that likely would change the verdict or a constitutional claim, like ineffective assistance of counsel or prosecutorial misconduct so severe that it deprived her of a fair trial. Those are high bars. Not impossible, but unlikely in the short term.
She's serving life without parole at Perryville and has been involved in prison programs, library aid work, music, selling art. She writes, she hints at further legal filings. Meanwhile, public fascination continues. That dynamic perpetrator as personality brand raises tricky ethics when supporters monetize art sales and Substack subscriptions tied to a convicted murderer. What are your thoughts on the ethics of consumption in this instance?
It's ethically fraught. On one hand, prisoners have limited means to rehabilitate or engage in pro-social activity, and art programs can be genuinely therapeutic. On the other hand, when proceeds support further legal maneuvers or public attention rather than restitution or accountability, it sits uncomfortably with victims' families. The legal system does permit prisoners certain outlets, but society must consider where lines are drawn when it intersects with celebrity economies.
This case also pushed conversation about gender in violent crime. Female perpetrators of intimate partner homicide are less common than male perpetrators, and our cultural scripts for understanding them are messy. Victims turned killers are often pathologized, sexualized, or both. The Arias case forced media and legal systems to reconcile that discomfort. Did they manage it well?
Not really. The media tended toward sensationalism rather than nuance. Discussions about gendered expectations, abused woman defenses, and psychiatric diagnoses became distorted by sound bites. That said, the trial and its coverage did force a broader public conversation about how gender shapes credibility, which is a conversation worth having, just not in 30-second cable segments.
Let's move into some hypotheticals, carefully framed. If new forensic evidence surfaced, say the murder weapon were found and ballistically linked, or a credible eyewitness emerged, how might that change retrospective analyses? Conversely, if clear, contemporaneous documentation of sustained physical abuse came forward, how would that reshape things?
If the weapon were found and ballistically matched to the bullet recovered from Travis, it would strengthen the prosecution's physical case and likely close a door that defense supporters pointed to. Ideally, it would remove a significant ambiguity. Conversely, verifiable contemporaneous documentation of sustained physical abuse, medical records, 911 calls, third-party witness reports, would dramatically alter the plausibility of the battered woman defense and could impact moral judgments about intent, possibly even affect sentencing if it were timely. Both scenarios would move the case from speculative gray to more concrete findings, but absent those, gray stays the landscape.
We're coming up toward wrap, but I want to leave listeners with a set of still unanswered questions, things you and I both think are worth sitting with. Number 1, was this cold, premeditated assassination or a catastrophic escalation of a volatile relationship? 2, what is the ethical line between exposing intimate evidence in service of the truth and voyeuristic exploitation? 3, did prosecutorial conduct or media spectacle meaningfully distort the fairness of the proceedings? 4, what led 2 jurors, once each, to withhold assent to death in a case where others found premeditation beyond a reasonable doubt? And 5, what does this case teach us about gender, power, and public appetite for simplified narratives?
All excellent. And each of those questions resists definitive answers because the record itself is partial and human interpretation is fallible. That's uncomfortable, but it's also instructive. Sometimes the best we can do is acknowledge that uncertainty and use it to refine how we investigate, prosecute, and consume stories about violence.
Before we close, I want you to answer, briefly, directly, what you think is the most plausible single explanation for what happened on June 4th, 2008. Not a verdict, just a professional reading, one sentence.
The most plausible reading, to me, is that a previously volatile, emotionally charged relationship produced a confrontation that had elements of planning but also escalated into frenzied, lethal violence. So a hybrid of premeditation and catastrophic escalation rather than a neatly packaged category.
Elena here. My brief take. The physical evidence and the behavior pattern suggest preparation, but the extremity of the wounds and the ambiguous sequence leave room for a narrative of dissociation and escalation. In other words, we're looking at a messy human collision of planning and panic, which is precisely why the case refuses easy closure. Calvin, any final practical takeaways for listeners who follow true crime closely and want to think ethically about cases like this?
A few. 1. Demand primary sources, court documents, transcripts, when you can, rather than summaries. 2. Recognize your own narrative impulses. Our brains like tidy stories, but human behavior rarely fits. 3. When someone claims abuse, take it seriously, but evaluate corroboration carefully. And 4. Remember the human toll. The families, witnesses, and even the people inside prison are living consequences, not plot devices.
Thank you, Kelvin. For listeners who want to dig deeper, court opinions from the Arizona Court of Appeals, trial transcripts from Maricopa County, and the Discovery Plus documentary If I Can't Have You offer fuller records. Also, Shanna Hogan's book, Picture Perfect, compiles a particular narrative lens. Read it critically. We'll link to a resource list on our episode page. For those of you who followed this case for years, what do you still find unresolved? Email us, stillunanswered@podcastexample.org. Tell your perspective. We'll share selected voices in future episodes.
Elena, one last note for listeners. When you encounter a sensational case, resist the urge to choose a side purely on emotion. Try to hold complexity and empathy together. It's hard, but necessary.
We'll end with that. Thank you, Kelvin. And thank you, listeners, for staying with us through a difficult, unsettling story. If you appreciate Still Unanswered, please subscribe and share. Carefully meaning, share with people who can sit with ambiguity. I'm Elena Marquez. Until next time, stay curious and hold the gray.